Let's just give a couple of minutes. There the recording goes. So yes, good evening, everybody. As I've just mentioned, we'll be continuing where we left off yesterday evening with the ethics. If it's all in order with everybody again, we'll just be having a short break again, just to a comfort break, and hopefully we'll be able to finish a bit earlier today. There was a request yesterday in relation to the lecture today, so that we first do the content. So we first work through the relevant content pertaining to the slides and the content of the guide, and then to do the questions only pertaining to the content of the work right towards the end of the lecture, to open then the floor up for questions. So I hope that's in order with everybody. So let's do that tonight. So please keep a pen and paper beside you. So if you have a question during the course of the lecture, please just jot it down, and then we can deal with those questions as soon as we actually finished with the content of the work. Is that in order with everybody?
Yes, Prof.
Okay,
Yes, Prof.
perfect. So that's what we'll be doing tonight. So first the content
In
and
order.
then any questions. And also we can just then keep the questions as well. We can also then just type them in the comment box towards the end if that's in order with everybody. There was somebody's hand that was raised. Was there a specific question that you wanted to ask right before we start? Otherwise, we'll be kicking off where we left yesterday in relation to the ethics lecture. Specifically, we were dealing, as I've said, the attorney has a relationship towards his clients specifically, and we'll be continuing with that focus. I'm going to share my screen. There we go. All right. And as I've mentioned, as a legal practitioner, and the rules of professional conduct is applicable to your relationship with your clients, your relationship with other practitioners, in relation to courts, the community, the state, and also the Legal Practice Council. So we are going to focus, the guide focuses on all of these. The main focus is on the relationship between the attorney and the relevant client. So that is what we're currently busy with. Yesterday, we had a quick look in relation to the application of FICA to relevant clients, and also the importance of obtaining a power of attorney in case that it is necessary in relation to the mandate that you do accept. We talked about mediation and the importance of mediation. And I mentioned that you must please just have a look at the advantages of mediation that's mentioned on page 53 of your guide. And also, which might come in very handy, as the professional negligence checklist that you find on page 55 of your guide. So today we are going to continue with confidentiality. And as we know, in relation to the attorney-client relationship, is confidentiality is key. So confidentiality is essential. All communication with attorneys are confidential. Yes.
Sorry, Prof. I just noticed there's an icon coming up. This call is no longer being recorded.
Just give me a second. I can just.
But it shows a red button in the far left corner.
I do see a red button, but I do see, I don't know if there's an extra presenter, because I do see somebody with an SM that's also got his cursor on at the moment. So if we can maybe just ask that individual to just not, but I do see that it's being recorded. So Kiswa, can we just get confirmation? Is the lecture currently being recorded?
I'm recording. It is being recorded.
Yes. Yes, no, I think yes. The recording, as I can see it, it's going in the top left hand of the screen, so it is currently being recorded. I'm just there we go. I'm going to minimize the screen, and then let's continue with confidentiality. So, as mentioned, confidentiality is key. And all communication with attorneys are confidential, and if it's breached, the attorney can be held liable, obviously, for damages. Can we just please ask Sambo to mute his or her mic? Sambo, if you're just able to mute your mic, thank you very much. There we go. So this includes all oral and documentary information, and obviously it is to create a safe space for your client and to enable you to provide the best advice to your client. Remember, as I've mentioned in the previous lecture, as FICA is applicable to an attorney, and to also to attorneys' firms, so is the POPI Act, the Protection of Personal Information Act. And you'll see a description of what those requirements are as on page 63 onwards in your guide. So please just be aware of the fact, equally as applicable as FICA is, so is the POPI Act, and an attorney needs to abide by those relevant qualifications in terms of the Act. Legal professional privilege. No attorney may disclose privileged information of a client to anybody unless they are ordered by a court of law. Privilege, and that is protection from evidential use of certain confidential matters. Without such a right, our adversarial system of litigation cannot operate properly, because obviously there is certain information that you would need to obtain from your relevant client. In relation to privilege, we have 4 legal requirements. The attorney should be acting in his or her professional capacity. The client consultant consulted with the attorney in confidence. The communication, whether it's written or oral, for the purpose of obtaining legal advice. And it's legal advice, and it's not advice to help someone to commit a crime. So obviously, if you do advise somebody to commit a crime, obviously that would not be subject to legal privilege. Then also important to take note of is the concept of prejudice and without prejudice. Without prejudice, the general position is that without prejudice, correspondence is inadmissible in court. It's ordinarily in an attempt to settle a matter. It does not constitute a waiver of a right or an admission of liability. All right, so if you want to settle a matter, you send your letter off and you have the words there that says without prejudice. So it does basically not mean a constitute of a waiver of a right or any admission of liability. What you should take note of, if it's not marked, but the purpose is of correspondence to make a genuine attempt to settle, it will still not be admissible in court, but obviously it would complicate the matter that much more, because you'll have to prove that that correspondence was intended to make a genuine attempt to settle a matter. So best thing is, if you're planning to correspond with another party, with an opposing party, in attempt to settle the matter, is to use the words without prejudice. In relation to conflict of interest, that relates to putting your own interests ahead of your professional responsibility. For example, where you act for both the plaintiff and defendant, that would be pose a conflict of interest, or where there's 2 accused. Those all can relate to conflicts of interest. In that regard, please have a look on page 79 of your guide, which should be able to provide you with, there we go. some more information in relation to that. So just have a look. Sorry, I'm just trying to scroll a bit quickly, but there I went far too fast. We'll get to the relevant page now, just so please bear with me. All right, so here is the details of privilege, and as I've mentioned as well, you can have a look at the relevant case law that is discussed there as examples. Conflict of interest is discussed there as well in greater detail. And there we have the examples of conflict of interest situations where a legal practitioner is requested to act for both the plaintiff and defendant. Do not be under a misapprehension that it is proper for you to act for both parties to a transaction because they consent or even insist that you act for both of them. A client can never be the arbiter of what professional propriety requires. The decision is yours as an attorney alone. So don't put yourself in that relevant situation of acting both for both parties. It would pose a relevant conflict of interest. Please have a look at these examples just as illustration and at the relevant relevant examples that's provided for you in your guide. All right. So that is the relevant requirements in relation to confidentiality that we know is essential. What is the legal requirements for privilege that should be focused on, what it means if there's communication without prejudice, and obviously the relevance of a conflict of interest. Then very important in relation to the attorney-client relationship and when you first consult with your client is the discussion in relation to fees. So when you receive instructions from a client, provide the client with a written cost estimate, and that cost estimate should include the financial implications, all fees and all charges, the attorney or the advocate's hourly fee and the right to negotiate fees, the outline of the work to be done in respect of each stage, the likelihood of you engaging an advocate and what their fees would be. So legal and financial consequences if the client should withdraw from a matter or if the litigation from litigation at any stage, what the cost recovery regime is. Also, if you do act on a contingency fee basis, you will need to have a look at the Contingency Fees Act and comply with the relevant requirement in relation to working on a contingency fee basis. And obviously, you need to explain, especially in relation to litigation, what the different legal costs pertain to. So very, very important is to have the fees discussion with your client and to provide your client right at the outset with a written cost estimate. All right, the different costs, party and party costs. Those are costs that have been incurred by a party to legal proceedings that the other party is ordered to pay. Not all costs that might have been incurred. It's only those that appear to the taxing master to have been necessary and proper for enforcing rights or defending rights. Attorney-client costs, an attorney is entitled to recover for professional services rendered. These are payable by the client, whatever the outcome of the case is, and not dependent upon a costs award by a court. That should be explained to the client quite clearly. Attorney-owned client costs, remuneration an attorney is entitled to in terms of the mandate or the agreement with the relevant client, costs in advance. An attorney is entitled to request deposits of costs in advance. We know that it remains the property of the client and it's deposited into the trust account. So it is not yours until after you've rendered the service and billed the client accordingly. And then an interim bill, not entitled to remuneration until the matter is finalized, and you can, however, agree to an interim bill. Right. So these different concepts should be explained to the relevant client. if there is ensuing litigation, that he or she might be responsible for party and party costs, but also attorney and client costs. So costs are very important aspects in relation to your client, and discussing this for you with your client, to be open and transparent in relation to the fees that's being charged. Now, contingency fees, we know that's an arrangement between a legal practitioner and his client, in terms whereof payment of the legal fee will depend on the result that's obtained. It used to not to be allowed, but it's now regulated by the Contingency Fees Act. It is now allowed if the legal practitioner believes that there is a reasonable prospect of success, and then to enter into such an agreement with the relevant client. All right, so that is basically a fee which the attorney can claim if they win the case. Two types of contingency fees: the attorney's normal fees for services rendered. There may also be a success fee in addition to the normal fee. The higher fee may not exceed the attorney's normal fees by more than 100%. And then secondly, the attorney's fee cannot be more than 25% of the capital sum of the award, whichever is the lesser. So those are the different contingency types that is provided for. If you do act on a contingency fee basis, your fees agreement should set out that you should not be entitled to the fees unless you're successful to the extent that's set out in the agreement. And then again, in relation to the specific reference to the relevant act, sections 2.2, you shall be entitled to the fees equal to or higher than normal fees as set out in the agreement. The higher fee compromises of the normal fee together with the success fee. A client should be informed that if the case is unsuccessful, they might be liable for the taxed party and party costs of the opposing party. So there is still the risk of a cost order against a client. The Act specifically excludes certain cases of being taken on a contingency basis that you should be aware of. So those include criminal proceedings and proceedings in family law matters. So if you do plan to act on a contingency fee basis, obviously it would be very important for you to study the Act and the relevant requirements in relation to contingency fees quite closely. And then obviously, if you do act on a contingency fee basis, it's very important to make sure that the client understands exactly what that means and the costs that would be confirmed in relation to this contingency basis. All right. Do not overcharge clients. Attorney that's found guilty of overreaching can be removed from the role. I don't think that should be the PLC, it's the LPC. The LPC provides guidelines in relation to fees if there's no statutory tariff that exists. And please have a look on page 92, the factors that the taxing master take into account when taxing a bill of costs. We can just quickly refer to these on page 92. Let's just have a quick look. There we go. Let's just move over to page 92 of the guide and look specifically at contingency fee and contingency fee basis. Sorry, not contingency fees. Sorry, what the taxing master takes account of. Sorry, my mind is wandering as I'm scrolling. All right, so the taxing master, when taxing a bill of costs, will be guided by the following principles: the amount and the importance of the work done, the complexity of the matter or the difficulty or novelty of the work or the questions that's raised, the skill, the labor, the specialized knowledge and responsibility involved on the part of the legal practitioner. So obviously, if you are a specialist in the field, you'll be able to obviously charge a rate accordingly. the number and importance of the documents that's prepared or perused without necessarily having regard to the length, the place where and the circumstances in which the services or any part thereof were rendered, the time that was spent by the legal practitioner, the amount of value where money or property is involved, the importance of the matter to the client, the quality of the work done, that's very important, and the experience or seniority of the legal practitioner. So obviously, a senior legal counsel would obviously be able to charge more, for example, than a junior in relevant circumstances. So that should be considered. So in relation to taxing a bill of costs, that is what the relevant taxing master will have a look at in considering taxing that relevant bill. So remember the written notice of costs that must be provided to a client when you accept an instruction. Very important. Also that we touched on yesterday was the importance of the trust account. We know that when we operate as attorneys, we have a trust account. So all practicing attorneys, trust accounts advocates must have a Fidelity Fund certificate. Referral advocates may not hold another person's money in the course of their practice, so obviously they are not required to have such a certificate. If you don't have a Fidelity Fund certificate, you may not hold funds or property on behalf of a client, and you may not receive deposits on account for fees or disbursements in respect of services rendered. A first-time trust account practitioner must complete all the legal practice management course, and then pay a prescribed fee and provide proof of such to the LPC when applying for that Fidelity Fund certificate. So obviously, you want to be a practicing attorney with a trust practicing in a trust account. You have to complete that practice management course. It is offered by Lead as well. I provided there just the link for you in relation to that course, and we can just quickly have a look there what it refers to. There you go. There it refers to the practice management training that's provided by Lead. And in terms of this course, obviously, that is necessary that you comply with the course, obviously, in obtaining that Fidelity Fund certificate. So here are all the relevant details in relation to the course, the costs, etc., is set out here on Lead's website. So if you want any further information in relation to the course, you're more than welcome to make use of that link and then to see exactly. They even have the module layout there in order for you to comply, and then in order for you, with the payment of the fee, to get your Fidelity Fund certificate. So the Fidelity Fund certificate is valid for a year, and then you obviously have to reapply. And reapplying, you must present your previous certificate, and then a certificate from an auditor that your trust account has been audited, and the relevant fee that is again payable. All right. Very important in relation to a trust account, you keep money on behalf of the client. The money is not your money. Very important. Most attorneys that are scrapped from the role would be in relation to the misappropriation of trust account funds. So you can invest in a separate trust savings account or another interest-bearing account, any money that is not immediately required, and then any interest that's accrued has to be paid over to the Fidelity Fund. All right. If the money is invested on request of the client, 5% of the interest accrued is payable to the fund, and then the balance is paid to the client. So if the client asks you to please, whilst the money is in your trust account, to please go invest it, you invest it on behalf of the client. The client gets most of the interest, but 5% of that interest is then paid over to the Fidelity Fund. There's a duty to report to the Legal Practice Council if money in the account is less and your trust account is less than the credit balances, with a written explanation and a correction. A report of a client's account is in a debit. The reason, therefore, and the correction or any irregular conduct that is picked up on your trust account needs to be reported and your correction needs to be shown. And obviously, that's the importance of having this trust account audited on a yearly basis. Please have a look on page 96 onwards of your guide. There's obviously special arrangements with most South African banks in relation to trust accounts and their management. If you want to open a trust account, obviously you go to the bank. There's special arrangement. You tell them you want to open a trust account. They know exactly what to do. So there's an arrangement with most banks in relation to the opening of these trust accounts and how they are run. They obviously must be properly managed and accounting records kept. They must be open even if there is no trust funds. Very important, never transfer trust funds to your business account unless they are due to you and you have proper accounts has been kept. So your services has been rendered, the money is now due to you, you send your bill to your relevant client, and then only then can the money be transferred if it is owed to you. All right, if you transfer estimated fees, that is unprofessional conduct. So it's only fees that is due to you in relation to services rendered. All right. Important is Section 87 of the Legal Practice Act requires proper accounting, which includes money received and paid on its own account, money received, held, or paid on account of any other person, money invested in a trust account or other interest-bearing account, any interest on money invested which is paid over or credited, despite having to be audited by your own auditors. If the LPC feels like it, they can audit your trust account, or if there's any complaints about an irregularity, or if a client complains, your trust account can independently be audited by the Legal Practice Council. Unidentified trust money, which is unclaimed for over a year, has to be paid over to the Fidelity Fund. If the client is later identified, then that client can claim those monies from the Fidelity Fund. Obviously, if you have any unidentified trust money in your trust account, it means that you've not been keeping proper account. And that is definitely something that should be flagged. If needed, the council can apply to the High Court to prohibit a practitioner from operating a trust fund and appoint a curator bonus to do so. Please have a look in relation to Rule 54.14 on page 99 onwards, pertaining to the management of trust accounts in relation to your guide. So please make sure that you have a look there in relation to all of the details pertaining to the management of a trust account. Remember that these slides guide you through your relevant actual guide. So please, if you're unsure about anything, there's a lot of examples that's provided in your guide, in your guideline, that you can go and study and read through if you are uncertain about anything. All right. So that is the trust account and the importance of a trust account. Very important is the fact that that trust account needs to be properly managed, properly audited on a regular basis as well. And as soon as there is any transgressions that's happening, or a client feels or a client lays a complaint, that trust account can be audited then by the LPC. All right, removal from role, something that we don't want to happen. So failure by a legal practitioner to comply with any provisions of the LPA or rules may result in the legal practitioner to be called for a disciplinary hearing, obviously before a disciplinary committee. If you are found guilty of misconduct, they can apply to have the practitioner struck from the role, suspend them from practice, or interdict them from dealing with any trust monies. And it basically means that you are no longer considered to be a fit and proper person to act as an attorney. Theft of trust funds is a very serious offence, and unfortunately it is the most common offence for which practitioners are suspended or struck from the role. So just remember, trust fund money is not your money. You keep that money on behalf of the client. As I've just mentioned, you cannot just only be removed from the role, but you can also be criminally prosecuted. Also, in relation to trust funds, what you should be aware of is the operation of fraud syndicates in relation to trust funds. Please have a look on page 105 in relation to fraud syndicates that target attorneys' trust fund accounts. The onus is on the practitioner to ensure that the recipient account belongs to the payee when a payment is made. The bank does not check that. It is your responsibility as the holder of the account to make sure that that is checked. The Fidelity Fund is not legally bound to assist practitioners who fall victim to this kind of fraud. And obviously, unfortunately, in today's day and time with electronic banking, etc., these fraud syndicates are a reality. So please make sure that you are aware of it and that you double check all your transactions and that you make sure that you have got control over your trust account. Bridging finance for those of you that would be conveyancers or are planning to be conveyancers, you're more than welcome to have a read through in relation to bridging finance that's discussed on page 105 of your guides onwards. Is everybody still keeping up? Just seeing if you're alive.
Yes.
Yes,
All
thank
right.
you.
Yes, Prof, we are.
I'm not going too fast, am I?
No, that's perfect.
All
No,
right.
it's okay.
We're
Okay,
copying,
perfect.
Prof.
Are you coping? Perfect. So, all right. Then the termination of a mandate. A client can terminate their mandate with you at any time. An attorney cannot withdraw. If an attorney wants to withdraw, they have to have a sound reason to withdraw. If a client terminates a mandate, you have to withdraw as an attorney of record and file that withdrawal, obviously, with the relevant court. A sound reason for an attorney to withdraw can include if there is any improper conduct on part of the client, if you find that there is any deliberate fraud, if there is any serious personality clashes, if a client does not accept advice, or if they persist on defending an action, if the attorney advises them that settlement is in their best interests, and obviously as well, if they fail to provide funds, if they fail to pay you, that is also a sound reason why you would want to terminate your relevant mandate. And you are entitled to your funds up until the point of the termination of the mandate. So a client, whenever they want to, they can terminate your mandate. An attorney needs to terminate the mandate with good reason, and the reasons are included as you see there. All right. So that is basically, we've discussed the first leg. Remember the relationship and the importance of the relationship between attorney and client. And now we move on with the relationship between an attorney and third parties and colleagues. There's a general duty of care that's regulated by the law of delect. You should not take advantage of a third party if they are unrepresented or negotiate a transaction whilst you are aware that a third person is not aware of their rights. All right. Very important is to, as an attorney or as an advocate, is to be collegial. Although you are on opposing sides, we are all colleagues, and it's very necessary to maintain a good relationship with colleagues. You also never know when you have to go and knock on somebody's door for advice in future. So it's always very important to maintain a good relationship, even if you are on opposing sides. It is accepted principle that it is improper, whether directly or through another, to contact the client of another legal practitioner without their consent. So if somebody is represented, you know that you know that that person is represented. You cannot contact that person directly. You need to first contact the legal practitioner and ask for permission to contact the relevant person. All right. Witnesses. So this is the attorney's relationship in relation to witnesses. A legal practitioner or a client does not owe a witness. An attorney can interview any person who they believe is in possession of information which may assist their case and cannot be deprived of this right by the fact that the other party has taken a statement or subpoenaed the person. The other side should be notified, obviously, of the interview beforehand. In relation to state witnesses, we'll now quickly have a look at page 117, but always be cautious to witnesses at all times. Do not be rude to witnesses. Be cautious, be professional. Sorry, it seems like I've jumped there a bit. We're just quickly going to have a look at the guide on page 117. There we go. In relation to witnesses, with regard to state witnesses, the Constitutional Court has ruled that the rule of practice prohibiting the interviewing of a state witness by an accused or his legal representative without the permission of the prosecuting authority is unconstitutional. An accused person has a right to consult a state witness without prior permission of the prosecuting authority in circumstances where his or her right to a fair trial could be impaired. If on the special facts of a particular case, the accused cannot properly obtain a fair trial, the accused or his representative should in such circumstances approach the NPA for consent to hold such a consultation. If such consent is granted, the Attorney General of such or such official shall be entitled to be present at the consultation. If the consent of the Attorney General is refused, the accused is then entitled to approach the court for permission to consult with a witness. The right to consult does not entitle an accused person to compel such a consultation if the state witness either declines to be consulted or if it is established on behalf of the state that there are reasonable grounds to believe that the consultation might lead to intimidation or to the disclosure of state secrets or the identity of any informers. So in relation to state witnesses, please take note of these guidelines and as well as the relevant case law that is applicable there. Right, so that is the attorney's relationship in relation to witnesses. All right, and then also in relation to counsel. So in relation to counsel, we're also just quickly going to have a look there at the guide on page 118. In our relationship with counsel, bear the following in mind. it is an attorney's duty to provide counsel with full and comprehensive instructions. The brief must be given in good time. It must be arranged in a proper manner. The attorney controls the case in instances where his clients elect to brief counsel to appear in the High Court rather than the attorney himself. The attorney must attend all consultations as well as the court proceedings. You do not send your client on their own to go consult with the advocate. You are present at all consultations, and consultations take place in chamber. During the hearing, the attorney must interfere as little as possible. The attorney must ensure that counsel does not communicate with the client directly. You are there and you take charge basically of that communication. Only in the most exceptional circumstances should there be a deviation from the general principles that consultations should be held in counsel's chambers. So in other words, again, consultations are at chambers. Attorneys or competent candidate attorneys should, without exception, always be present when an advocate consults with clients. So you or your CA will need to be present when there's a consultation with counsel, and it takes place at chambers. All right. In the Fortune case, it was held that an attorney certified in terms of the right of appearance of court in relation to obviously appearing in our higher courts, signing of pleadings in place of advocate, requirement of Rule 18.1 of the Uniform Rules, that all pleadings have to be signed by an advocate, certified attorney signing pleadings under Section 3.4 of the Act. So just take note of the specific rules pertaining to that. So obviously specific duties that we have towards counsel, and it is very important to take heed of that, and very important in relation. So never think that you should not be present when there's a consultation with the relevant counsel. The attorney always has to be present, and those consultations take place in chambers. All right. And very important in relation for counsel, especially if you want to make use of their services in future again, is to pay the relevant fees timeously. All right, then court. So this is the attorney's relationship in relation to the court. So an attorney is admitted to practice as such by the court, and also removed as such if it's necessary. If it's necessary or deemed to be fit. So all attorney and all legal practitioners are officers of the court. There's a duty not to abuse the process of the court or hamper your opponents in the conduct of their case. There's a duty towards the court and responsibility towards colleagues to act honestly, conscientiously, and openly for the proper administration of justice. Very important is to dress suitably, and before your first appearance, if you do appear and if you've got a right of appearance in relation to the higher courts, is to introduce yourself to the relevant judicial officer and chambers. Be courteous to court staff, especially as candidate attorneys. Court staff are the people that makes everything tick, so it is not going to be to your benefit or your firm's benefit to be rude to court staff. You'll find that if you are, that it will be troublesome for you to obtain files or information in the future. So it's very important to have a professional relationship and a courteous relationship with all court staff. Remember that as CAs, that is usually the CA's main job, is to do all of the court work, to go to court, to file, to go obtain documents. So your relationship with the court staff is especially important. In court, know when to be silent, when you should not speak or even whisper. That is when an oath is administered, when a prisoner is being sentenced, when judgment is being delivered, where either when the court is opened or closed, or when a prisoner is being arraigned. All right. When a judge or a magistrate enters or leaves the court, a bow is made towards the bench. And when you leave or enter the court, you bow towards the bench. Rather hand counsel a note than discuss something in court or whisper in court. So rather, if you want to point his attention to something specifically, just rather hand a note to your relevant counsel. To address a high court as my lord or my lady, my lordship or my ladyship outside of court. For example, in chambers, you would refer to the individual as judge. Magistrate's court, in court, it's your worship. Outside, it would be magistrate. Stand up when you address court and sit down when the other party is addressing the court. Be properly instructed and prepared. You would be amazed when you sit in court, attorneys that are not properly instructed or prepared, and it really reflects bad on the relevant individual, and more so as to the detriment of that relevant client. Robe and bib, dark clothes underneath, that is just custom. Black bottoms, and for ladies, closed shoes. You robe beforehand. You do not robe inside the court. And also only if you are appearing. So if you are not appearing, you would not be robed. Always, and I've highlighted this before, be courteous to the opposing party and any witnesses. You should know by now and probably have dealt with it if you are doing your articles of clerkship. Cases are now managed through a court online evidence management application, or it's known as case lines. So you will need to familiarize yourself with the system. And obviously, every court's jurisdiction has got different rules and practices that needs to be, abided by. So when you go to a different court within a different jurisdiction, make sure that you are that you have knowledge of what is required in that specific court, any practices that should be heeded in relation to that specific court that you will be appearing before. So these are just general rules in relation to professional conduct in relation to the court, and also to be always professional and courteous to all relevant court staff. Remember that we are all officers of the court, and if you do plan to appear before court, and if you do plan to go into litigation and specialize in litigation, it would obviously be to your best benefit to have a very good relationship in relation to the courts and to be seen to be professional at all times. So would it be in order? It's now 19 minutes past 6. If we just have a quick 10-minute break until past before we start with insurance. Would a quick break be in order, everybody?
Yes, Prof.
Yes.
All right.
Yes, thank you.
Order, Prof.
Yes, Prof.
Let's just do a quick
Thank you.
water break. 10 minutes. It's now 18:19. Let's be back here at 18:30. We keep it to 10 minutes, and then we kick off again.
Thank you. Thank you.
Thank you, Prof.
Thank you.
Itumeleng, please mute yourself.
It smells so good. It smells very good. It's beautiful and fresh. Ah,
Silence in court.
Hi guys, thank you. I'm back. I just quickly scrolled through the relevant chats. I see that there was just some discussion on a lien. So if a client terminates a mandate, there is the possibility, or let me just explain the concept of a lien. So attorney has a lien over the documents which she doesn't own, which belong to the client and which were drafted by the attorney and for which that attorney can charge a fee. Lien is a defense against an owner's res vindicatio, and that it allows a creditor to hold or retain control until that person has been paid. So obviously when a client terminates his mandate, he's obviously entitled to all of the relevant documents, but if that client has not paid you yet, you can exercise this lien. So this lien can be exercised over all documents that the attorney drafted or letters that's been sent on the client's behalf. Practically put, this means an attorney can retain the client's documents until that client then pays the relevant attorney. So that is with reference to a lien. That is referred to in your guide. So if there is a mandate that's terminated, an attorney has a right to exercise a lien until that attorney obviously has been paid for the relevant services that attorney has rendered. All right, but without further ado, let's just continue with the relevant lecture. We'll get to all of the chats and all of the questions as soon as we have gone through the content of the work. Now, insurance. So, Legal Practice Insurance Indemnity Fund, the LPIIF, is basically negligence by a legal practitioner, and special extension is provided to support staff. And you have to be in the possession of a valid Fidelity Fund certificate. The Legal Practitioners Fidelity Fund.
I just want to
Yes.
check if you're sharing your screen.
Sorry. Thank you guys for alerting me. Let me quickly share. There we go. Right. So the Legal Practitioners Insurance Indemnity Fund, that is where there's negligence by a legal practitioner, and there's also in certain, it's also extended to support staff. You have to be in possession of a valid Fidelity Fund certificate. So that is the first type of insurance. And then the second is the Legal Practitioners Fidelity Fund. That is where there is the misappropriation of trust funds. this is to the benefit of the client.
Hi, Prof.
Claimants,
Sorry to disturb. Sorry, on my screen it shows that the call is no longer being recorded. I don't know if maybe that's a mistake.
I think it is being recorded. I can still see at my top hand at the top of my screen that it is still being recorded. Let me just double check.
I can also see it's being recorded, Prof.
Yes, no, it looks like the recording is continuing, so it might just be a mistaken notification, but I can see that it's still, the recording is still running from this side.
Okay, thank you, Prof.
It's a pleasure. So the Legal Practitioners Fidelity Fund, where there's a misappropriation of trust funds, here the benefit is to the client. So claimants should first try and claim directly from the legal practitioner if they are not able to claim from the Fidelity Fund. And in this regard, have a look at section 34 2B of the LPC. Let me just quickly have a look at that specific section. Sections on page 139 of your guide. There we go. So the fund is liable to reimburse persons who suffers loss not exceeding the amount that's determined by time to time by the minister and the government gazette as a result of the theft of any money or any property that's kept in a trust account. All right. So specifically, the section refers to by a legal practitioner in that practice or advocate or any person employed by that practice or supervised by that legal practitioner or advocate, by a legal practitioner or person acting as an executor or the administrator of an estate of a deceased person, or by a legal practitioner or person employed by that legal practitioner who is a trustee in an insolvent estate or in any other similar capacity, excluding a curator to a financial institution in terms of the Banks Act, or a liquidator of a mutual bank in terms of the Mutual Banks Act. So that is to whom this is applicable, and if the theft is committed by those specific individuals, the client has a right of recourse against the legal practitioner's fidelity fund. A claim must be lodged within 3 months of becoming aware of the theft, or reasonably ought to have been aware. It does not protect the practitioner, but it protects the public. So if trust funds has been stolen, you can't get hold of the relevant attorney, then you institute a claim against the legal practitioner's fidelity fund. And in that specific instance, the client has to institute that claim within 3 months of becoming aware of the theft. Many firms have additional cover, and some firms may even request this cover before instructing an attorney. So that is in relation to, especially in relation to negligence, firms can obtain additional cover. All right. Client management, obviously key. Very important is to remember to enter into a fees agreement with your client. Section 35(7) is important here. We'll just quickly have a look at the section itself on page 141. There we go. When any attorney first receives instructions from a client for the rendering of litigious or non-litigious legal services, or as soon as practically possible thereafter, the attorney must provide the client with a cost estimate notice in writing, specifying all particulars relating to the costs of the legal services. And we've already sort of touched on this. So the likely financial implications, including fees, charges, disbursement, and other costs. hourly fee rate and an explanation to the client of his right to negotiate the fees that's payable to the attorney, the likelihood, as we've said, of engaging an advocate, as well as the fees of that advocate, if the matter involves litigation, the legal and financial consequences of the client's withdrawal from the litigation, as well as the cost recovery regime. So as I've mentioned before, this is key and very, very important to discuss the relevant cost implications with a client. Okay. It is recommended that an attorney should have a double database to register and record clients' cases, and also remember that you've got to FICA the relevant clients, and there is a lot of tips in relation to how these databases could be kept and how clients' records should be dealt with, and you can have a read through on page 142 onwards in that regard. So that is that, and now we can deal with all of the questions, and I hope it's a better format to first do the work and then to be able to discuss and work through the relevant comments to that extent. So I'm just gonna move over to the questions, and we'll have a look at the chats as well. Our first hand is Cora. Cora, do you have a question?
I apologize, Prof. I actually raised my hand or incorrectly when you asked us if we keep up with your lecture. So please ignore me.
No problem. I'll just lower that hand. Ali Richard.
Thanks, Prof. Good evening, Prof, and to the colleagues. Prof, if you don't have the answer now, I would like to, if there's a rule or a document or a directive on this specific topic. We were talking about fees earlier on. Now, what I want to find out is, currently are fees regulated in South Africa, and which body regulates that fees? Because the public perceptions out there that everybody, every attorney, high-ranking advocates, senior counsels, just charge exorbitant amount of fees. Now, we're going to enter into the field soon. Is fees regulated currently in South Africa? And can that document or that rule or directive from the Law Society or the LPC maybe just be made available to us as to how we calculate fees? That's the first one. Then my second one is, you've mentioned earlier for me to obtain a fidelity certificate after my articles is I need to do the LPMA and the IPM, which is the practice management, and the IPM is the introduction to practice management, and then the legal practitioner's account management course again. Now that course is currently covered in our curriculum and in our training. Must we do it again? Because we're already covering that aspect of in this PVT training. And then my last one is what rules govern when we go out in practice with regard to advertising? Is there circular? Is there certain rules? How we can advertise our business once we're out into the field, especially with social media today. We don't go anymore to the newspapers to advertise. We do everything social media advertising. What rules governs us and guidelines when we advertise our business as legal practitioners? And then the last one is basically just a comment I want to make is on the etiquette. the dress code is nice, everything. And I must say, from a personal point of view, I've reported an attorney about 2 years ago. They came to court. It was on a Wednesday, and the attorney had a hangover. You could still smell the alcohol on his breath, like he had a drink like 10 minutes ago. And that's very important, is not to come to court having alcohol, breath smells, and bubbelas on your when you interact in court. And the Legal Practice Council did take action against the attorney. Yeah, that's just, I take a drink, but if I know I've got a long court case tomorrow, I stop drinking at 5, 6 o'clock in the evening. Yeah, it's just that. Thanks, Prof.
No, that's fine. So let me the first question is on the relevant fees. There is guidelines that's provided by the LPC. I think I've made reference to them in the slides as well, in relation to fees that's charged, that should be charged. So obviously that is the baseline, or the general fees fees structure that's provided for. But just remember that obviously there is instances where one could deviate from that, and that would obviously, for example, depend on the relevant speciality field that you are dealing with, as well as, for example, is it a very complicated matter? For example, if you think about intellectual property matters, etc., when we're dealing with trademarks, etc., or any intellectual property, that might be seen as a very specialized field. So obviously the person that specializes within those fields would be able to charge more. And also, for example, something like seniority comes into play here. For example, as I've mentioned, a senior legal practitioner is able to charge more than a junior legal practitioner. So these are also all factors that's taken into account. But yes, the guidelines that I'm referring to is also taken into account, obviously, by the relevant taxing masters when they tax. So they've got more or less an idea of what should be charged, what is reasonable to be charged. And that is one of the reasons, especially when we litigate in relation to party-to-party costs, why bills are taxed, to ensure that they are not exorbitant. So yes, there are these guidelines. I'll see if I can draw them down and then just provide them to Zukiswa so that she can forward them to everybody. But there are certain guidelines that is provided by the LPC in relation to fees that's charged. Then I think in relation to the practice management course, I think the reference, I'm not too sure, and I'm speaking under correction, it does not refer to a relevant accounting course, but it refers to legal practice managements. The legal practice management course. And as I've mentioned, if you go to that relevant course, so this is the prescribed course in relation to obtaining that legal practice certificate. The modules that you do there is general introduction to management, risk management and insurance, law, business, finance, systems and technology, practice administration, the marketing of legal services. That's also one question that you've asked here, is about the marketing of legal services. So there are guidelines that do exist in relation to advertising legal services. One thing is that we're not allowed as attorneys to tout for work, and obviously it would also, for example, to be improper to say, for example, to advertise special all divorces only 5,000 rands or whatever the case might be. So it is regulated, and when you do this specific course in relation to practice management, you will specifically be informed on how to market your legal services. So, and that counts irrespective of the format that you use. So you've mentioned that it used to be via newspapers, etc., but now we've moved over to social media. But the same rules are applicable. You're not able to tout for any legal services, and you need to conduct yourself in a proper manner. Also, that forms part of that courses like human resources management, etc., and strategic management. So that is the requirements for for the course. I'm not aware that you have to undertake basic accounting. Remember, as you've just said, accounting does form part of our compulsory training as candidate attorneys as well. In relation to dress for courts, yes, our courts do take that quite seriously. So ensure that you are always properly dressed, but as I've said, most of these rules in relation, for example, to not going smelling of alcohol to the courts is applicable to any professional employment, is just to follow those guidelines. And remember, it's your reputation that's on online. People notice, and the legal fraternity is actually a pretty small place. People talk, advocates talk, and you might find that you get less and less referrals if you don't conduct yourself in an appropriate manner. So I hope that answers your questions. I'll see if I can get hold of those fees structures, but there is a guidelines that is available, and obviously that the taxing master also is aware of in relation to charging legal fees. Nkgopotse, you've got a question?
Sorry, Prof.
Yes.
Before you move to Nkgopotse, I'm sorry, Nkgopotse, to
Yes.
interject. I had a question that is related to dress code. If I am the instructing attorney and you have counsel that's arguing the case of my client, should I also be robed, or it's okay if I just show up? Because I am expected to show up
Yes,
in court.
obviously you're expected to show up. You are not expected to robe, so it's the person that would be arguing, so it would be counsel, but you should obviously be neatly dressed, suit and tie, next to your relevant counsel.
Awesome. Thanks, Prof.
It's a pleasure. Nkgopotse?
Yes, thanks, Prof. First question. On the trust account, if the firm has two practicing attorneys, 50-50 directorship, ownership of the business registered, and both of them have fidelity fund certificate, how does that work? Are they only going to audit their books using one attorney's fidelity fund, or both fidelity fund certificates will be used? Second question, when we introduce ourselves at chambers, is there a procedure, or you just introduce yourself whichever way? Third question, it is mentioned that the fidelity, the legal insurance fund is to protect properties in the trust account. Can there be any other properties except money in the trust account? The last question, I want clarity on the double database to register. What does it mean? Thank you.
Just remind me of what your first question was on again.
My first question was on the trust account.
The trust accounts.
Where there is two practicing attorneys, but they operating under one firm, and both of them have fidelity. Is it a requirement for both of them to have fidelity fund certificates separately, if they are 50-50 shareholders in terms of directorship?
Remember that every practicing attorney has to have a fidelity fund certificate. So that is the requirement. What was your second question? Sorry, you had so many questions, I lost you somewhere. So your first question was on, yes, second question
was on the introduction at chambers. Is there a procedure or a manner in how we introduce ourselves, or we just go in and introduce yourself, your name, and where you're from?
All right. And the last question was on?
On the guide, it talks about other properties in the trust account. My assumption was that the only thing that will be in a trust account will be money. What other forms of properties are there in the trust account? And the last question is seeking clarity on double data base for registering.
Sorry, I'm just making notes. Introduction to chambers is obviously, you can't just barge in and introduce yourself. So if it's the first time appearing before the relevant court, you have to timeously, so well before court starts, you will need to go to chambers. You need to introduce yourself to the relevant clerk of the court and ask the clerk of the court if it would be all right if you proceed to introduce yourself. The clerk would then take you into chambers, and then you just say, I am so and so and so from this firm. This would be my first time appearing before you, and that is basically it. So obviously you report to the relevant chamber, you report to the relevant clerk, and that clerk then takes you forward. In relation to what is kept in trust account, remember a property can also have a monetary value. So that is the reference to that. But in relation to trust account and all the details in terms of the auditors and what is exactly required, please make sure that you read your guide very carefully in terms of, and also the prescripts of the relevant legislation. Unfortunately, we don't have time within this format to go through, and it's as well with yesterday's questions in relation to admissions. We don't have time to go through all of the legislation, all of the subsections. So please make sure that if you do have a specific question, that you also study the applicable legislation in relation to that. Then the last question in terms of the double database, it is just not in terms of registering, but it's in terms of safekeeping clients' data. So it's important, and it's to just keep a double database in terms of not if you lose it, that you've got a backup. So that is the reference to double data.
Okay, thanks, Prof.
All right, thank you, Umkhopotse. Adam, do you have a question? Adam Badenhorst.
Yes, good evening, Professor. Can you hear me?
Yes, I can.
Hello, Professor. Okay,
yes,
perfect.
I can hear you.
Professor, I have two queries. The first one is in relation to the slides. I believe your slide, I think it's number 18 or 19, when we refer to contingency. Some of your paragraphs differ from the ones that we have when we downloaded from the eLido platform. I think specifically yours says it has figures saying 100% or 20% on there that's not on ours. Are we able to get a copy of your latest PDF?
Yes, no, I'll make sure that I forward that to Kiswa, and also there's one or two of yesterday's as well. For example, the Bacha case that I referred to, that's also included. I'll make sure that I forward the updated slides to Zakiswa, and then she can just distribute that to you.
Okay, thank you, Professor. And then just on my second point, in order for our preparing for the exam, is these PDF documents sufficient with the relevant pages that are mentioned, or do we have to ensure that we know the complete study guide or training guide?
You can use the slides as a baseline.
Okay.
What I would advise in terms of preparing and in terms of preparing for the test is to go through the slides first and foremost, refer to those specific pages as well. But in terms of the guide and how to use the guide, is read through it, but you don't have to, for example, know the specifics of the examples or the case law. Those are illustrative. So I think the most important thing would be to focus on the core, which is mostly discussed in the slides, but also to expand on that. And if you've got any uncertainties as well in the guide. But I mean, the guide is very illustrative. There's lots of examples. So focus on the core principles and the guide as well. But obviously you don't have to know the case law, etc. The points of illustration in detail.
Okay, perfect. Thank you, Professor. That's all my questions answered.
All right, thank you, Adam. Next one, Adam Sabia.
Good evening, Prof, and good evening to colleagues. Prof, as I have only 3 questions, and I think a short one. One is on the cost in advance. What happened if a client pays in cash? Yeah. Number 2, it's on the trust account, where I want to know if the Fidelity Fund certificate, we can only apply it once we are admitted, or we can apply it during the process of in the article of clerkship. And then the last one is, does an attorney allowed to terminate the contract with the council if there is maybe a disagreement in terms of instructions? Thank you.
All right, in relation to costs in advance, obviously, in relation to costs in advance, you're only able, that costs that's paid in advance obviously should be paid into the relevant trust account. So if the client makes pays cash in relation to costs in advance, you need to deposit that cash in the relevant trust account. Only once you've rendered the applicable service and you've billed the relevant client, are you then able to obviously transfer that money to your account? If there's anything that is extra, obviously that should be paid back to the client, whatever the case might be. So if a client pays in advance, that money needs obviously to deposit it into the trust account and then administered accordingly. The second one was on articles of clerkship, and can you apply for a Fidelity Fund certificate? The answer is no. Obviously, you need to be an admitted attorney to apply for a Fidelity Fund certificate. And then if there's disagreement with council, can you terminate the mandate? The rules would be equally applicable in relation to when you can terminate a mandate in relation to council. But obviously, if council has already been, this needs to be also in consultation with your relevant client, and the implications of that should be explained to your client. Do you need another council? What is those implications going to be before you actually proceed and terminate the relevant mandate with council? And also, again, just be very careful in relation, and it's very important to make sure that you brief the correct counsel before there is any speak of termination of a mandate. So make sure that you are absolutely 100% sure of the counsel that you brief, that you've got a very good working relationship with the relevant counsel, instead of having to terminate a brief with counsel. I hope that addresses all of your questions.
Yeah,
I can move.
Thanks a lot, Prof.
Okay, I'm going to move on to the next one. Bella Cholofelo.
Sorry, Prof, and sorry, Tsulu. I had a question on a similar subject as Adam on termination.
Yes.
Recently, I think I was just listening to the news and I saw that Thabo Bester's attorneys or counsel actually just terminated very close to the day when they're supposed to be on court, or on the time that they were supposed to be in court. And my question really is, when is it reasonable to terminate? Like, from an attorney's perspective or a counsel's perspective, and what is the court's discretion on intervening in trying to prevent terminations that lead to frustration of the wheels of justice from spinning? Because we've seen a lot of this, particularly in South Africa. I think our honorable President Zuma is one of exemplary examples of such tactics. And when does this justice system say enough is enough? and prevent attorneys from terminating, especially if we look into those and we realize that there are no reasons to terminate other than the fact that someone is trying to frustrate the wheels of justice from turning.
Yes, that's a relevant question, but also a quite difficult question to address. So obviously, attorney has got the full right to terminate a mandate. Sometimes in criminal trials, unfortunately, you'll find that mandates are terminated, right before a hearing. You then get to court, a postponement needs to be asked because a mandate has been terminated, whatever the case might be. Obviously, it's unprofessional to do so, but attorney has got a right to terminate a relevant mandate. And unfortunately, we don't have the insight in relation to why that mandate has been terminated by the attorney. It might be that there was a severe clash of personalities that I've referred to, or there might be that the client has asked the counsel to do something illegal, whatever the case might be. Unfortunately, there is not much that a judge can do. There's no legislation or anything that regulates it, except for a judge to obviously, alert the relevant attorney, whatever to the case, or the fact that it's very inconvenient, or whatever the case might be. And in relation to our ex-president, President Zuma, yes. Obviously, his legal tactics is to try and postpone matters as far as it's possible. I think he's a vexatious litigator, if one can put it like that. But it's also very difficult because remember that each of us has got the right to access to courts. So if we do plan at all to bring any claims against Mr. Zuma, you should be able to have to prove them. So unfortunately, it is an immense frustration in relation to justice. But at this stage, there's not much to be done, unless we have specific legislation that will be promulgated that regulates the relevant situation. But yes, but also not good for an attorney to terminate his mandate just right before or right in the middle of something, because it just reflects very badly and in relation to your reputation and in receiving future briefs from clients.
Sorry, Prof.
Yes.
It does cover it to extent, but it just raises a few questions. I think I've seen a few judgments where the judge would almost direct towards development of the law, right? And at what point do we get to that point where everyone realizes that, for a lack of a better word, this is nonsense and it needs to stop, and something has to be done? Because I feel that if you study the history of our law, we've seen where judges have gotten to a place where they almost directed the development of legislation that actually covers certain parts. And when does that happen with this particular element? Because you see it almost every day. You see our colleagues or our future colleagues dragging huge briefcases only to get there and actually withdraw or postpone a case. And I'm just thinking, we've been waiting for this ruling or for this case to actually take place. And I can quote many cases that are in our public sphere that are actually going through the same thing. And it's really frustrating. And it's frustrating for one who is a candidate in this particular profession, but it's even more vexatious for a person who's just a bystander watching from the bleachers on what is happening here.
Yes. So I know that there obviously is the principle of a vexatious litigator. I'm not exactly sure what the requirements is to actually be what the relevant requirements is to be classified as a vexatious litigator, but there is that option within our law. I'm not exactly sure to what extent this has been applicable in relation to Zuma. The problem with Zuma is that he always has a reason or a supposed reason for for frustrating the ends of justice. In relation to judges pointing to this in their judgments, remember that it's very important to uphold, to uphold this, the principle of separation of powers. So judges cannot just simply develop the law in relation to suggesting, what it should be. For that purpose, unfortunately, real change will only be able to be made if there is specific legislation in relation to vexatious litigators. I'm not too sure what the exact principles is in relation to the requirements for a vexatious litigant, but that is basically what it would boil down to, especially in relation to Zuma. But that is a vexatious litigant. It's not necessarily in reference to a vexatious litigator in relation to counsel. But if there is in relation to counsel's conduct, in relation to attorney's conduct, that is something that will have to be regulated by the Legal Practices Act, and that is something that we'll have to wait for the legislator to do. But obviously, the concept of a vexatious litigator comes to mind, and that is a possibility that can be used in relation to President Zuma. So I hope that provides you with some insight, and maybe just if you'd like to go and research the principle of a vexatious litigator. But again, it's in relation to the litigant, and not necessarily in relation to action of the relevant counsel. For that, we would need specific legislation. If I can move on to the next question.
Thanks, Prof. You can move on.
Thank you. If we can move on. Yes.
Sorry, I just want to ask, if we don't have any questions, are we allowed to leave the session?
If you don't have an interest in any of it, I take it that you can. We are going to continue tomorrow. We're finishing off tonight with the ethics. We are going to start tomorrow with the constitutional law practice, which is going to run for tomorrow and the next day. As I've mentioned before, in terms of constitutional law practice, we're not going to follow the guide, but I'll refer you to specific aspects of the guide that we will be focusing on. But if you don't have any interest in the relevant questions, we are finished with the content of the work, and then you are welcome to log off.
Okay, thank you.
Bella Sholofelo.
Thank you, Prof. Finally. So, Prof, my first question is with regards to POPIA. What happens in an instance where it's the state, let's say the police, require information of that particular client of which you've got information on regarding a criminal matter? Do we still follow POPIA, or we also have to look at into what does the Criminal Procedure Act says when they have to also execute their mandate in investigations?
Yes,
and then
yes, you continue.
Oh, okay.
Yes.
Then I just want to also state my second question. It's with regards to the costs and fees. Profit litigation matters. Is there a way that you can give a client an estimate, because you never know how far the matter will get? So how do you actually determine on doing an estimate invoice of your fees of how much you're going to get to charge them if you don't even know the outcome or where this matter will end up in terms of, particularly in litigation? Yeah, all the other questions the other colleagues have already asked what I had to say. I got responses on that.
All right. In relation to if the police wants information or whomever wants information in relation to your client, POPIA obviously the would be applicable to any information that you need to share in relation to your client and which you are able to share. So I'm not exactly sure exactly what, but it relates to, the relevant permission, how the information is kept, how the information would be transferred, etc. But obviously also remember attorney-client confidentiality in that regard in relation to sharing the relevant information. I'm not too sure exactly what, information, etc. the police can request from you in that regard, but obviously just remember that you've got attorney-client information. But in relation to handling any information of your client or handing over that information, papaya would be applicable. Your second question related to?
Costs, Prof, in terms of a litigation matter, because
Oh, yes.
earlier on you said,
How
yeah,
to
that we
structure the
need to.
costs. All right.
Yes.
So generally, obviously, you need to be very open with your client in relation to costs. So you'll have to, for example, just for example, if it's a divorce, you would more or less know what the costs is of a disputed divorce or one that is undisputed. You would know more or less what the cost would be for an advocate, but you then also need to advise your client, listen, you might lose, you might want to appeal. If that is the case, this might be the extra. So it's not an exact figure that you're going to provide, especially in relation to litigation, but it's more or less an estimate in relation to, I've mentioned those fees guidelines, an estimate in relation to those fees guidelines that you provide to your client. And as you become more familiar, obviously you would have more or less a feel for how much more or less how much it will cost. But obviously you also need to inform your client that nothing is certain, that there might be certain eventualities, so it is not an exact estimate of those relevant fees.
Thank you, Prof, for the clarity.
It's a pleasure. The next is it Fumani, did we address your question?
Not yet, Prof.
Okay, Fumani, your question?
My question is in relation to confidentiality, Prof. Are we allowed to discuss a client matter with another practitioner, whether from the same firm or a different firm, with a view that the sharing of that information will benefit the client?
Well, it depends on who you are sharing it with. So obviously in relation to confidentiality, the onus would still be on you in relation to that confidentiality. So if you would like to share it with somebody, you've got to ensure that that person is able to keep that information confidential as well. So my advice would be not unless it's obviously you'll be discussing it with counsel, whatever the case might be, but to be very careful in relation to the information that you share. If you'd like to receive advice, obviously in general from another colleague in relation to a colleague in a firm or whatever the case might be, don't provide specifics, ask in general, leave out the relevant client's name, etc. But yes, ultimately you are still responsible for the confidentiality of the relevant client's information. And obviously, you could always ask a colleague for help, but obviously do so anonymously.
All right, no, thank you.
Next question, Farzana.
Good evening, Prof.
Evening.
I have a very simple question. I just wanted to know, in terms of fees and costs, what is the difference between attorney's client costs and attorney's own client costs?
Did we not address that in the slides?
It broke it down, but once I've read it, I didn't see the difference, like whether there was something that sets them apart from each other, because both states that you receive your cost in payment from your own client, which is why I was a bit confused there.
Let me I just want to move to that specific slide and just get hold of it.
Professor, can I address you on that?
You're welcome to. I'm just searching for the summary. I just want to see what she is specifically referring to. But in the meantime, you can continue. Yes, please.
Professor, attorney-owned client cost is actually cost that is due to the attorney in terms of a mandate. That is when attorney is rendering fees, he can then charge his fees, and that will be due and payable by the client. But you have two scales when you do litigation. The one is the party and party scale, that is the cheaper scale that we refer to normally. And then you have your attorney-client scale on which you can tax bills. Both those scales must be based on a court order. So if the judge is of the view that there are reasons or prospects to grant a punitive cost order, then he will grant it on attorney-client order. So then, of course, when you prepare a bill of costs, which when we do the cost portion, they will explain to us exactly how to prepare an attorney-client bill. It has nothing to do, and I think there was some confusion in the slide with regards to that. So attorney-client is what the court can order when there's bad conduct, when the case is vexatious. That is just a more expensive scale on which you tax which fees will be due by the winning party. Attorney-owned client is what is due to the attorney payable by the owned client.
Thank you so much, Porter. That helped a lot.
No, that's a pleasure. I'll just go through the slides again and just make sure that it's absolutely clear and providing the revised slides, but also in general, in costs order in general, unless as explained, in general, costs are awarded on party-to-party scale. It's just, yes, as she mentioned, that in exceptional circumstances, it would be on attorney and attorney-client costs, which is the higher rate. But yes, that is the difference. And please you can always go for clarity. You can go to your guide as well, which gives a more in-depth explanations. You might sometimes find that the slides are a bit cryptic. And if you need any further explanations, you're more than welcome to go to the relevant guide.
Okay, thank you so much.
Pleasure. Sindisiwe.
Unmuted. Yeah, thanks, Prof. I've got two questions. It's about the Fidelity Fund. The first talks about the prescription of 3 months. Can that be bypassed if there's a valid reason why the client needs to claim from the Fidelity Fund and the lawyer acted illegally? The second question is, does a client have right to claim from the Fidelity Fund even if the client paid into the lawyer's personal account? Because there's some attorneys that act really, really dodge, where they'll make you pay into their personal account as opposed to the company account. But everything was conducted at the lawyer's practice.
All right. Obviously, it is, if I'm not mistaken, it's the specific wording says when the client 3 months from which time the client becomes aware of it. I just want to look at the specific wording in terms of the slides.
Okay.
Do you remember which slide, which number, slide number it referred to? There we go. Okay, it says become aware of the theft or reasonably ought to have been aware. So in terms of that specific wording, it therefore means that the 3 months can obviously be later, or you know, it can be condoned. But when that person reasonably ought to have been aware of the fact. So let's say it's, you know, so in other words, it's not that strict in relation to that. It is movable, reasonably ought to have been aware. Your second question was again?
In terms of if the client paid into the personal account of the lawyer.
unfortunately, it only relates to trust accounts. So, and that is also why a client needs to be very, very sure when they pay monies over that it is paid into the trust account. And that is one of the reasons why that Fidelity Fund certificate is so important, and that the payment is made into the relevant trust account, which will be clearly, obviously stated as such. But it's not for claims that was made into the relevant attorney's personal account. It's only in relation to the trust account that the Fidelity Fund is would be available to a client.
So, in just a follow up on that, so does that mean that there's no recourse? So the next step would be for the client, if the lawyer then disputes this, would be to open a criminal case.
The recourse would be to institute a claim against it, the attorney itself, obviously for fraud in terms of criminal, yes. So you'll have to institute a claim against that person, as well as a civil claim, obviously, as well. You can do both. But it would have to be recourse against the attorney's personal capacity, and not, you won't be able to go through the relevant Fidelity Fund.
Okay.
All right.
So
Next.
sorry, Prof.
Yes.
I had another question that actually just segued into Cindy's question.
Mm-hmm.
So, how much does the public know of their rights when it comes to you have to pay into the trust account and not the attorney's, personal account? And how much do we know about the fidelity insurance and the fact that we have to report them, and there are ways that we can report them, and how much work has actually been done by the Law Society of South Africa or any other legislation to ensure that the public knows of these recourses that exist?
Prof, can I jump in there?
Yes.
Just to answer Cornelia's question, I would assume that, and you can correct me if I'm wrong, that onus rests on the attorney to inform their clients of these things. And it's unlikely that someone who doesn't need an attorney is going to want to know about trust accounts necessarily. I don't know, but yeah, and I think in practice how it would work would be, I, as the legal practitioner, possess this knowledge, which I should have a duty to share with my clients. I don't know.
Well, in practice, they don't.
Yes, but that's the problem. I think first and foremost, obviously, if you go to an attorney, well, the attorney, when he accepts money for services for that should be kept in trust, the relevant or for costs in advance or whatever the case might be, the relevant client needs to be informed accordingly. The information, I don't think, I'm not sure how widely distributed the information is that you can claim against the Fidelity Fund, but obviously there are certain requirements, and as we've seen also a restriction on the amounts, etc., in relation to what can be claimed against the Fidelity Fund as well, that is legislated. But yes, so can the LPC do more? Most probably so. But yes, unfortunately, there is a lot of unscrupulous attorneys, and that is one of the reasons why it is so important to be informed of legal ethics, to conduct oneself ethically in relation to the legal profession, and then also if you are, and then if there's any uncertainty in relation to clients, they should direct any complaints to the LPC, and the LPC should act accordingly, and these relevant attorneys should be scrapped from the role. And but could more be done? Yes, most possibly there could be. I'm not too exactly certain to the extent to which the information is disseminated to the public, but there is protection that is provided to an extent to the public in relation to attorneys and dealings with trusts accounts. The next question, Michelle Louis.
So, sorry, Prof. I think it's probably because we're spending so much money paying the insurance instead of educating the public, because most of the attorneys are unscrupulous.
Yes, unfortunately, that is the reality of our profession.
Just to chime in there quickly, the last sitting of the board exams, Gauteng's results, like there was 11% pass rate for the ethics paper alone. So it says a lot.
Yeah,
Yes.
that does says a lot. It's telling.
Yes. Michelle, Louis, do you have a question?
Hi there. I had just a quick thing to bring up about costs, and then I've got a question about the Fidelity Fund. The question that was asked earlier about costs is why is a client entitled to attorney-client costs when they have to incur the costs of the attorney anyway? I just wanted to say that, for example, if somebody litigates against you and ultimately they are not successful, then you can get a cost order mandating them to pay your costs of having to go through that litigation, which ultimately wasn't your fault and didn't end up to be, they weren't successful, which is why there's that as well. But I know we'll go into that more when we do the cost seminar. So that was that. And then the second thing, my question on Fidelity Fund insurance is, how does one go about claiming as a client if the attorney has stolen your money, if they haven't paid their annual Fidelity Fund premiums? So then what is the recourse for somebody?
If the attorney hasn't renewed their Fidelity Fund certificate?
Correct, yeah.
I'm not exactly sure what the recourse would be against the fund, and if you have to have a valid Fidelity Fund certificate to claim, I suppose that that would not necessarily bar, but I'm not exactly sure exactly what the legislation says. So I think one should just go and have a look at the specific legislation, but I think you won't be barred. But obviously, if you do consult with a relevant attorney, that is one of the questions that you would need to have to ask is, do you have a valid Fidelity Fund certificate? Your first question in relation to costs, it would be obviously you are responsible for costs is awarded most often in terms of party-to-party scale. If you are the successful litigant, obviously costs follow suit in that regard. But obviously, you also might have still, as per your agreement, as per your mandate, in relation to costs that you are still due in relation to your attorney as well. Very important is to, when parties engage in litigation, to warn them of the fact that if you lose, that you might have a cost order that is also given against you. So in relation to the Fidelity Fund certificate, who can claim and for exactly what amounts and exactly what the requirements is, you'll just have to study the legislation a bit in relation to that a bit closer.
Thank you.
Sonwabile.
I think my question was raised by Adam and Gwanele a lot, but I just want to find out in terms of the termination of mandate with the client, specifically on the personality clashes, who determines that? And, do they look for a proof if there was personality clashes between the two parties? And the last question that I have also is the structure of the exam. I think somebody has raised that. I just want to find out if are we going to have an assignment on this and the exam at the end?
In terms of the structure of the assignment or the structure of the assessment, you'll just have to obtain clarity from Zukiswa, the administrator, and exactly what if it would be if it's going to be multiple choice or if it's going to be an assessment. In relation to termination of mandate as a result of personality clashes, no, there's not going to be asked to be proof. It is just that you are able to cancel to relinquish your mandate if you just if you don't see eye to eye with your client. Lots of times, well, sometimes you'll have clients that just does not take your advice, and obviously that can lead to a termination of mandate, and that is one of the reasons, as we've stated, why the courts, can't really enforce a mandate to that extent, because it would be very difficult to determine to what extent it is a personality clash or it is not. So, but it is a reason. If you can't get along with your client, obviously you can terminate the mandate.
Okay, thanks, Prof.
Pleasure, Huiti.
Good evening, Prof. Can you hear me?
Yes.
Oh, I've got two questions.
Yes.
Whereby it's with regard to the Fidelity Fund certificate, where two attorneys are both practicing attorneys, and they both have Fidelity Fund certificates.
Yes.
In terms of auditing, is there a dual auditing process in that regard?
I'm exactly not sure how they are audited. If there is a dual, if there is if they practice in a partnership, I can follow up with you for that and then just get back to you. But I'm not exactly sure how they are audited exactly technically.
Okay.
But I can get back to you on that. Did you have another question?
Yes, Prof. In terms of the Contingency Fees Act, right?
Yes.
Is there going to be a percentage that is determined for every matter, just like it is determined in ref matters? In ref matters, we know that the attorney is entitled to 25%, right?
Yeah,
Hello?
there's not as the set amounts are as indicated in the slides, and is also as indicated in the and this Contingency Fees Act specifically, but there is not a set amount for every specific, different type of litigation or different type of litigious matters. But if you want to know exactly what the requirements are, you'll just have to have a look at the relevant act.
All right. Thank you, Prof.
Renil Way.
Evening, Prof. Can you guys hear me?
Yes, we can.
My question, Huiti just actually answered it, so I was supposed to raise my hand down there. Thank you.
Okay, no, that's absolutely fine. Maudrey?
Yes, hi, good evening, Professor. I just have a question with regards to legal privilege. Can privileged documents be requested during discovery, and in what instances will the court order that privileged documents be produced?
Maudrey, I don't have an idea in relation to privilege and privileged documents and discovery. I'm actually not really sure. I can follow up with you and then just post the answer to Zukiswa, if that's in order.
Yes, please. Thank you.
It's a pleasure. Zanalik?
Evening, Prof. I just wanted to ask, do you consider this ethics guide to be sufficient for purposes of studying for the ethics portion of the attorney's practice exam?
That's a difficult one. Yes and no.
Wouldn't the case law be also very important because it's a practical exam, it's not theoretical?
Yes, for the exam itself, yes, but also in relation to the ethics exam for well, in general, in terms of the previous exam. I know as lecturers, or have a look at what they ask in the previous papers, exactly how they structure the questions in relation to ethics and what sort of questions they ask. I know as lecturers it's very wrong to say have a look at past papers, but that gives you an idea what questions are to be, are asked. I would not necessarily. You can use the guide, to assist, but not but don't just rely on the guide in relation to preparing for the ethics exam.
Okay, thank you so much, Prof.
It's a pleasure. Zandile?
Prof, and good evening, and as well to colleagues. So
My question is just an expansion on the trust with all the other questions that the colleagues asked. I just wanted to find out, say an attorney charges you maybe fixed costs on a matter, and then they include maybe consultation fee. And then I wanted to find out that the funds that are kept in the trust account, will they include that consultation fee? And then say then you have a difference of opinion with the attorney, you maybe want to, you prefer to handle the matter in a less costly manner, maybe through a round table or through alternative dispute resolution, and then the attorney advises you for maybe going through courts and then for summons. So would the client then be able to request the consultation fees back? Because normally before they proceed with your matter, they would request you to firstly maybe pay consultation fee. Do you have a right to then as a client to request for your reimbursement of your consultation fee?
So obviously the money that's kept in that's kept in trust, it's almost like a deposit. So you can only bill it once it's due to you, and then once it's but it would depend obviously, as indicated, you have a right to negotiate your fees with your relevant attorney in relation to what the consultation fee would be or whatever. So if a deposit is asked of a X amount, consultation fees can only be charged once obviously those has been held. It's clear, and obviously you can dispute your relevant bill that's been provided to you with your attorney and say, oh, I see, there's consultation, it's for 2 hours, but we only consulted for one, so I'm only willing to pay one, whatever the case, and negotiate to that extent, or query the bill to that extent. But remember that an attorney can't do anything without instruction. We solely act on instruction of our clients. So if you have a difference of opinion of how a matter should proceed, or how it should be dealt with, obviously you're not able to bill or to bill for money for work that you have not done or which your client have not given you permission to do. You can dispute the costs or whatever the case might be, but also if you've agreed that a consultation for an hour costs whatever amount of rand and you have consulted for an hour, obviously you are responsible for paying that relevant fee. So it would depend on what your agreement is with your relevant client and what the instruction is.
Okay, thank you, Prof.
Pleasure, Takalani. Takalani, questions? You can unmute your mic, Takalani.
Can you hear me now?
Now I can hear you, yes.
Thank you, Prof. I think most of the colleagues have asked this cost and fees, but I see here it's clearly said the instruction from a new client. The attorney or trust account advocate must provide the client with a written cost estimate. So,
yes.
Takalani, I don't think we can hear you. Can you type your question in the chat rather?
You can't hear me.
We can hear you now, Takalani.
We can hear you now, Takalani, yes.
The thing is, in terms of understanding, to say it's a risk-return cost estimate. So it means an estimate is not a true reflection. Now, if you agree with your client and then you have undercharged for the matter, and maybe the client already paid the money, and for you to continue and you need more money, what will happen now? Because you already agree with your client and you haven't finished the matter. The matter is still under litigation. So what must happen? Then the client can report the client, the attorney to
LPC or what?
Remember, as you've just stated yourself, so it's merely an estimate. So if it's if a matter becomes, sometimes it's more complicated than it actually seems to be. There's more things that needs to be done, etc. Whatever the case might be. Obviously, you'll go back to your client and say, as a result of X, Y, and Z, the bill would need to be adjusted. These extra costs would have to be incurred. And obviously, you need to take instructions in relation to how the matter is going to be taken further, receive such instructions, and obviously, if more money needs to be paid, obviously, the client would make another deposit in relation to taking the matter further, whatever the case might be. Sometimes it means that you need another counsel, or that you need to brief senior and junior counsel, whatever the case might be. Costs need to be adjusted. You need to go back to your client and say, this is the state of it. You need to pay a further deposit. And obviously, if the client refuses to do so, obviously you can terminate your mandate.
Okay, Prof. But it's a worry factor, this thing of estimate. Unless if you are saying the LPC will provide us with the fixed rates. So it's very difficult, but we'll learn as time goes. Thank you, Prof.
Yes, it's a pleasure. Deborah? Deborah,
Thank
do you
you.
have a question? Yes.
Yes, Prof. Good evening. Thank you, Prof. I'm going through your slides and the notes just to make sure that I also make sure that we covered everything. I see 8.1 in our notes, contempt of court. We haven't gone through it, or you haven't emphasized it on your slides. Does it mean I can ignore it?
I would just read through it.
Okay, you'll just read through it. Okay, thank you. Thank you, Prof.
All right, perfect. Is there any further questions?
Yes, Prof. I just had one last question that I did not get to. Unfortunately, I had raised my hand, but I think every time I just interjected, my hand got accidentally dropped. I think it's a Teams functionality there. One last question that I did not get to was just around the fine line between my personal life as an individual, which obviously is formed by morals and education and all things that I've learned as an individual person. And these would apply to me whether I was an engineer, a chartered accountant, or whatever profession that I had decided to go with, versus my professional life as an attorney, which is dictated by, legal ethics or rules of conduct for the particular profession. What is the fine line between the two lives? Is there even a thing such as a fine line that separates between the two?
So obviously, your own moral compass or your own moral ethics a lot of the time coincides with the ethics of the legal profession. To that extent, but obviously you as a legal, but obviously you've got to recognize that as individuals we all have our own set of morals and ethics that we comply with depending on who we are, our backgrounds, etc. The thing is just that as a legal practitioner, we've got a heightened sense of ethics to conduct ourselves ethically, which is legislated upon. And if we don't conduct ourselves ethically, we can be disbarred from the legal profession. So yes, it's a responsibility that stretches both ways. It is a fine line, but as a legal profession, you need to have a heightened sense of ethics. Unfortunately, as some of the students have mentioned, that is not always that evident in the legal profession, but obviously it is to your own detriment. If you do not have that moral compass, and if you do not abide by the relevant ethics that's set by the relevant provision. So you have your own set of legal ethics, but also then the prescribed legal ethics in terms of legislation that you need to abide by.
Thanks, Prof. I think it's very clear to me that the measure that is put on me as a candidate practitioner or a legal practitioner is more stringent than what would be put on me as an individual, because that could be predicated by the fact that I'm either a Christian, a Muslim, a Hindu, whatever the circumstances are, or I grew up in the Eastern Cape, or I grew up in Gauteng. It's likely that if I want to succeed as a legal practitioner, then my moral compass has to be almost has to comply with the legal ethics. But we find that very different in practice, where most practitioners will look for ways to actually live through their moral compass in the in the legal profession by finding what many people have termed as loopholes. And I don't know if this is a question or a comment, but most probably a comment. And yeah, it's just disgusting to watch sometimes.
Yes, and that's one of the reasons why we have these courses, etc., because you find that what you think is ethical and moral and would be the same as somebody else would think, you quickly realize it's like common sense. It's not that common. You quickly realize. So what you think is moral and ethical would not necessarily be thought by somebody else to be moral and ethical, and that is why the profession is regulated as such as well. Then our last question. I think, Huwiti, do you have a final question there?
Yes, Prof.
Yes.
My question is with regards to being a director of a company when it comes to admission, right? So if you were a director, right? If you are a director, but the company has been deregistered due to non-compliance because the company has never actually made profit. Actually, you've never, what do you call it? The company has never been in operation, right? So does that mean then that you no longer a director, or do you still have to apply to CIPC to formally remove you as a director?
Prof, can I answer that?
You're welcome to.
So the process of deregistering a company is governed by the Companies Act, and so you would do the CIPC process as well as the process stipulated within the Companies Act, and I think also the Insolvency Act, a section applies there related to solvent companies, the dissolution of solvent companies. So you'd follow that process by publishing in the Gazette and giving notice, that kind of thing, so that any potential creditors can come forward and state whether the company is liable to them. So yeah.
All
yes,
right.
so
Thank you so much.
Yes, you are still responsible to remove yourself as a director.
Okay, Prof. Thank you.
Last one, Ketiwe. This is the final question for the evening. Ketiwe, anything?
So my question relates to admission. So if there are, because what happened with me, just a quick summary, is that I was at a law firm and then I left the law firm, right? Because there were dubious things that were happening and I don't in a precarious situation. So if I'm trying to get admitted and now I have to basically make a vehemence as to why I left the previous law firm, do I have to specify exactly why? like in detail.
Were the articles seeded?
No, so I did almost here, and now I'm here. So they were not seeded at all. So I just walked away.
So the articles weren't seeded. You'll have a look at the act, specifically what is the requirements in relation to that, but I don't think it would be that big a problem in relation to the fact. So you're basically starting from scratch with
Would
a
I
new
have to start
with
from
a new
scratch?
contract.
No, now I'm not doing articles at this present moment, but so I did like almost 2 years, just under 2 years at a previous firm, so in that particular contract. So what I'm trying to establish is, would I have to get a new contract after this course is complete? Would I have to get a new contract and do another year, or?
But you've already done 2 years. Have you completed your degree already?
Yes.
So you've completed your articles of clerkship?
No, I didn't do the full 2 years. There was a month or 2 left, and I walked away because there was shady stuff going on, and I didn't want my name to be attached to the shadiness.
That is going to be quite complicated in terms if you like that time to count towards your articles, you'll have to set it out in your relevant application, and also. And that's why I'm saying, just please go read the Act very carefully, because remember, you also need an affidavit from your ex-principal or your principal in relation to that. And how would you be able to obtain such an affidavit if you've left the firm? So just make sure that you comply with all the requirements in relation to that, because I know that you would need, if you don't seed your articles of clerkship, obviously in terms of your application, all of those facts you'll have to disclose, and also you might run into problems of how are you planning to get your affidavit from your previous principal.
Okay.
Sandili, do you have a comment, or do you have a specific question pertaining to the content of the work?
Prof and fellow colleagues, it's also a question that relates to admissions, ma'am.
Yes.
Yes, Miss. My scenario, I think, is a bit different from other fellow colleagues, because I'm currently doing my articles with the private legal practitioner, and also I'm employed at a TVET sector as a teacher. So I finish all my classes every day before 12, and then after that, do that 5-minute walk to the office where I practice as a candidate legal practitioner. So I'm not too sure.
Is it a private law firm?
Yeah, it's not a private. Yeah, I'd say so, because it's me. I'm allowed the attorneys.
All right. Now, in terms of the requirements of the Act, you cannot be employed in any other. You can't be employed as both as a teacher, or have a side contract. You can only be employed as a candidate attorney. So you can't have both.
Oh, okay.
All
No,
right.
thanks, Prof.
In relation to admissions, I just advise everybody to really go read the prescripts of the Act very, very closely. If you've got a case of where your admissions is going to be more complicated, the best thing would be is to go to ask for advice, and also ask for advice in relation to similar situation from maybe a previous candidate attorney that had the same, or from which, and also to ask the Legal Practice Council in relation to your admission, to ask for advice and guidance in that regard. Bila, do you have a specific question?
Prof, it was just a comment on what Sandile was saying now. I just wanted to check with him if, for example, with me, I'm currently working for provincial government in legal services. And the plan is that, so I'm doing my vocational training now. Then next year, the request would be for the HOD to second me to state attorney for my articles. So if Sandile is working for the Department of Education, because I know there was law now that we can be seconded to state attorney, can't he perhaps go that route instead of this thing that he's doing now of after work, he's going to this law firm, and maybe find out if Department of Education can't also maybe second him to state attorney to serve his articles for a year, of which in my case, the HOD said, then I'm gonna owe him a year, meaning once I'm done with state attorney, I come back to economic development, finish that year, then if I want to leave the department, then I can leave. Perhaps he should try find out if he can't get what I'll be getting in the next coming year.
Yes, but that is specifically an arrangement that would be with relation to the state attorney, so that would be regulated as well. All right, I think that is all the questions for this evening. We are going to be wrapping up with ethics tonight. I'll meet everybody tomorrow again at 5:30 for constitutional law practice. I think you already have got the slides that's been shared by Zukiswa, so I'll see everybody tomorrow evening. Have a very good evening and meet everybody tomorrow.
Okay,
Thanks,
thank you,
Prof.
Prof.
Thanks,
Thanks,
Prof.
Prof.
Thanks,
Thank
Prof.
you.
Bye. Thank
Bye.
you.
Good night, guys.
Thanks,
Bye.
Bye. Bye. Bye. Sure.
Bye.